Good afternoon, everybody, and welcome to our very first post-COVID hybrid event. We're pleased to see so many of you here in person to act as our studio audience, and we're thrilled to be able to stream our programming to so many of you around the country. For those of you who aren't familiar with the NAI, we are the leading trade association and self-regulatory organization dedicated to maintaining and enforcing high privacy standards for data collection and use in digital advertising. The NAI recently added the tagline that you see behind me: privacy, trust, accountability, because it is our mission to restore consumer and business trust in digital advertising through strong privacy principles and guidance, and to compel companies to be accountable to consumers and their business partners for their data collection and use practices. Part of fulfilling that mission is initiating conversations about the challenges and opportunities in our industry, and there are many. So that's what we're doing today. We're delighted to have with us a number of special guests who are eminent experts in data protection and privacy, and I have the honor of introducing two of them. The NAI has a long history of working with the FTC on privacy, and we're excited to continue that collaboration today. It is my pleasure to introduce to you FTC Commissioner Noah Phillips. Commissioner Phillips was confirmed by the Senate in April of 2018, and prior to his FTC service, Commissioner Phillips worked with Senator John Cornyn and the Senate Judiciary Committee and was a litigator with Cravath, Swain and Moore and Steptoe and Johnson. He holds an undergraduate degree from Dartmouth College and a JD from Stanford Law School. Joining Commissioner Phillips in our conversation today is Professor James Cooper. Professor Cooper is an associate professor of law at the Antonin Scalia Law School at George Mason University and the director of its program on economics and privacy. Professor Cooper also has significant FTC experience, having served as the deputy and acting director of the Office of Policy Planning, an advisor to FTC Commissioner William Kovacic, and most recently as a deputy director in the Bureau of Consumer Protection. Professor Cooper's widely published research focuses on the law and economics of privacy, data security and consumer protection, as well as competition policy. Professor Cooper holds a BA from the University of South Carolina, a PhD from Emory University, and a JD from the Antonin Scalia Law School. So with that, let's get started. Please join me in welcoming Commissioner Phillips and Professor Cooper to the stage. Welcome.
Thanks. All right. Well, it's great to be here, Noah. As I was saying, it seems we get together and do this about every 6 months. So I'll see you again in June. I think so.
Yes, and welcome everyone to the Cooper-Phillips show.
Yeah, Phillips, though my intro was longer.
True. I need to work on that.
Yeah. All right, well, we have limited time here and a lot to cover, so I want to get started. First, and clearly because we're here at NAI, privacy is kind of top of mind. So on the recent report to Congress on privacy and data security back in September, you dissented, and you noticed several concerns over several issues, and we'll get into that in a sec, but first, I want to start with kind of first principles, sort of a foundational question. In your view, what types of privacy harms do you think should concern the FTC? I mean, do you think it should be limited to monetary harms, sort of identity theft harms that have always been in the sweet spot of the FTC and certainly rank among, if not the highest every year as far as complaints? And if not, what do you think the limiting principles are on how far Section 5 should go in addressing informational injury, for lack of a better word? So what do you think, Noah?
Sure, and let me sort of back up just for a moment and thank NAI for having me, and thank you for being here. It's a delight actually to be back in person, yes. And I'm supposed to offer the caveat that, what I'm going to say is just my view and not necessarily the view of the Commission. But I think that's fairly evident to everybody. And who knows, it may become more evident over time. So on privacy harms, my general view of the thing is twofold. First, we have a statute, right? And when it comes to unfairness, We have to show substantial injury. That's not like a whatever we want to do. That's a congressional instruction. It doesn't need to be limited to out-of-pocket harms, but there is definitely an instruction there from Congress to focus on some sort of subset of injury that is lesser than the whole. The second thing, and I think it's important not to lose sight of this, I think we do our best work in general in consumer protection, but also specifically in the context of privacy, when we put an emphasis on where people are being harmed more. Right? So I'll take two recent privacy cases that matter, and those are cases involving stalking apps. Now, that's not an easy monetary harm, but it's a rare person, I think, who would dispute that some of the conduct going on can be really harmful to people. I think that kind of focus is good. I think it's consistent with the congressional instruction, but I also think it's beneficial that if we have limited government resources, we ought to focus on areas where people are in some way being hurt. Let me add the following. A lot of the privacy discussion, not all of it, but a lot of it has to do with harms that I think are debatable as harms in the first instance, and then a little bit more subjective and value-laden. So let me give an example. I was in Boston last week talking to a class, and I followed Shoshana Zuboff, a professor at Harvard Business School. And Professor Zuboff focuses on things like dignitary harms and harms to democracy. And dignity is important, democracy is important, but one person's view of what constitutes a dignitary harm, or even more so, one person's view of what constitutes a harm to democracy can differ dramatically, and that doesn't, in my view, give us the kind of guidance that we need to predicate liability. Those are the kinds of things, perhaps, that Congress ought to consider when it fashions privacy policy, right? Congress could look at, given a kind of conduct, and say, even if that doesn't meet the unfairness test in the FTC statute, we still either want to regulate it or bar it, what have you. But the critical point there is that that's a congressional determination, and that value judgment of good or bad, even without the presence of harm, something that, like you could find in tort, is left with elected representatives.
Yeah, so I think that's a good, first I would have loved to have seen you and Professor Zuboff on the same stage, or at least following each other. I'd like to have seen if where the Venn diagram and agreement would have been there. That would have been worth the price of admission. But I think your point about Congress making the cut is a nice segue to what I wanted to get to next. So do you think that the FTC right now has sufficient authority in the field of privacy and data security? So there are a couple parts of this. I mean, one, there's certainly a lot in you read the press. There's at least some thought that the FTC may be sort of greasing the wheels to get ready to do some sort of privacy rulemaking, something. And I understand, I mean, if you want to break some news and talk about all that today, that's fine. But I understand that there are certain things you're probably unable to get into. But I would like to at least get your views on whether you think right now the extent to which, without any additional congressional action, the FTC has authority to engage in privacy or data security rulemaking under Section 18?
So I think we do have some authority, right? Under Magmos, we can make rules. We need to show the prevalence of the thing, and we need to show illegality, right? It needs either to be deceptive or unfair. And I think there's definitely room to look at different kinds of conduct. Let me add, though, one thing. I think we're definitely at the point where, done right, I could support a data security rule. Mm-hmm. But the scope of what people want when they talk about privacy, and frankly, the lack of clarity that you see in some of the public discourse, lead me to the conclusion that if we're going to make rules on privacy, the place to start is Congress. Right? If they want to give us rulemaking authority, as they have in the context of COPPA, that's all well and good, but just stepping in as legislators and having the votes of 2 or 3 people determine what is going to be the role for the economy, without all of the other considerations, by the way, that Congress has been struggling with, right, about liability and preemption, things like that. I think that's us overstepping our bounds. I also think it is a process that is necessarily going to disappoint. It is very easy to sit here and say, oh, we'll make a rule, and everyone in the world has an opinion of what that's going to be. But there are limits to the authority, and the rulemaking process is what it is. And I think that for the FTC to get into it, we'd both be overstepping our sort of fundamental role in the world. But also, I think you're going to find a lot of people, including advocates, who are very enthusiastic about the prospect of rulemaking, disappointed with the result.
Yeah. So, what do you mentioned? Okay, this is likely a job for Congress to make these decisions. What would you like if it, and I know that in joint testimony you have supported some sort of congressional action in privacy and data security to give the FTC authority. What would this look like? Would it look like rulemaking? How much discretion would you want Congress to give the FTC to define harms? And it sounds from your, what we're just talking about, maybe not a ton of discretion, maybe this, and then what sort of remedies do you think the FTC should have at its disposal to enforce whatever authority Congress were to give the FTC? So just kind of broadly, what would this bill look like if you could write it? What would it, like you used to when you're on the Hill? Yeah.
Well, the critical thing, when I was on the Hill, I worked for someone who was elected. And I don't think it's up to us as the FTC to write law.
Yeah.
I think we can implement law, and that includes regulation under certain circumstances, but fundamentally, the big value judgments, what's a harm that ought to result in a penalty or what have you, those are really, at best, those are congressional judgments. My rough sense of the world, like a lot of laws that are passed, will get penalty authority. That makes sense. I think Congress needs to work things out in terms of a lot of the remedial scheme, though, right? You have big debates over private rights of action and preemption. To my mind, and I've said this in Congress, one of the things you hear a lot about privacy is that people don't have a sense of what's happening with data that are collected from them, right? It's a sense of what's going on. To me, preemption is not just important for making it easier for businesses, right? That can invest more in engineers than they invest in lawyers doing compliance. It's also helpful to consumers, right? If you've got a patchwork of different laws, it's going to be harder to understand, and that's going to exacerbate the problem. Right now, right, we're all faced with these options when we visit a website, and some of those options are now conditioned on whether we live in California. That doesn't seem like the best way to do this. Along similar lines, I do think there ought to be Congress ought to look at what they can do, what we can do to help bridge this gap of lack of understanding. Are there things that can be done that give the consumer better knowledge without going through these long, documents and reading them, which nobody does. So I think that definitely ought to be an area of focus.
Okay. So again, sort of related to Congress giving FTC or working somehow to give FTC a little more authority here. Another thing, and again, you and your colleagues have, and this is a long bipartisan FTC call, has been for more money, more FTEs to address privacy and data security. So would you envision, and I know that this is in one bill, that funding bill, I think that's kicking around Capitol Hill. I mean, number one, do you think that we need more, I'm sorry, I don't work there anymore. Do you think the FTC does need more funding and FTEs in this area? And would you see this as, again, I think one bill on Capitol Hill and other commentators have suggested, as moving DPIP out of BCP and sort of having a bureau of privacy and identity protection for whatever it would be called. So, instead of having the Bureau of Economics, Bureau of Consumer Protection, and Bureau of Competition, and then DPIP residing within that, it would be on equal to the others. I mean, how do you think there needs to be some sort of fundamental transformation in the way the FTC is set up to deal with privacy and data security to put it more on an even level playing field with the types of data protection authority you see in other countries.
In other countries.
Yeah.
So let me start with the following. My view is that the privacy work that we do at FTC is the best in the world. And I think if you look at the impact of the work that DPIP in particular, but the Bureau of Consumer Protection more broadly has done over the years, the companies they've put under order, the remedies they've secured, the innovative cases that they've brought, and I mentioned those stalking apps recently. Yeah. I think we're having, even without a general privacy law, as big or bigger an impact than any other DPA, in Europe or elsewhere. And I'm very proud of that fact.
Let me just interject and say I agree wholeheartedly with you on that. Going back to when I was representing the FTC in various fora like this, and you'd always hear that. I always say that, that the FTC, I mean, I'd agree with everything the FTC does in the area, but certainly a lot more impact than I think any other data protection authority in the world. Completely agree, so.
To me, that's important. But, we do it on kind of a shoestring set of laws and with a shoestring amount of people. If you look at the numbers of the Irish DPA, or I just bumped into some folks from the British Information Commissioner's Office, the ICO, DPIP, which are not the only people that work on these issues, it's a small fraction of the number of people. So I think we could use more people, and I think we could use more money, right? Some of the money is used for people, but some of the money is used elsewhere. I think those would be helpful additions to our toolkit. Some of the numbers that I think you see in Congress strike me as so big, just organizing it could be a problem, but I do think there is room for more resources and for more people to help enforce the laws that we do have. And as we talked about just a moment ago, I'm a proponent of a little bit more on data protection, both in terms of data security, but also in terms of privacy. In terms of, do we need a Bureau of Privacy? That to me is secondary, right? Like sometimes when we talk about issues in tech, you'll hear someone say, oh, we need like a Department of Technology, or we need some new agency. This is like the old joke in Washington of task forcing something. It's a great way to show that you're for whatever you're for without specifying what it is. I think we'd be fine with a Bureau of DPIP. I think DPIP, the way it works now, is pretty good. Again, I think they're having a big impact. That's a secondary question in my mind to the more important questions about resources and tools, whether they be monetary or legislative.
Okay. So I want to, sticking with the privacy theme, but switching gears a little bit, moving to an area I know you've thought and written a lot about, the interface between privacy and competition. So returning to the privacy and data security report, one of the aspects you criticized the majority for was the seeming call to use to kind of merge competition and consumer protection in perhaps not the most thought out way, and using competition remedies to go after what are essentially privacy concerns where there may not be any antitrust concerns. So I wanted, if you can elaborate on some of these concerns, and then maybe more generally, how do you see privacy and competition kind of coming together? Because again, I know it's something you've thought a lot about.
Sure. And this idea that we should be using antitrust to solve the privacy problems of the world, this is not a new thing, but it's very voguish right now. So Pamela Jones-Harbor talked about it way back when, but more recently this is coming out of, heads of agencies and heads of this, that, and the other thing in Europe and America. And the problem, well, let me start with what I agree with. In antitrust law, we look not only at price, but we also look at, aspects of quality. And if we think, let's say in a merger, that you're going to see a lessening of competition over this aspect of quality, that's a reason to be concerned about it and potentially a reason to remediate. But there is a lot of, privacy and antitrust are not the same. And in fact, in many ways, they work at cross purposes. So let me just give a kind of notional example of this. The access to data, right, which is a kind of asset upon which competition can be predicated, is generally good for competition, right? Opening up more resources to more players in the market. But opening up access to more resources that are data about people raises privacy concerns. So here's a general area where the two are at odds. And I think you see this tension playing out in some of the complaints that we see, as we move on the internet from a system where there is more ability to access data, including buying it, to walled gardens, right? So when Apple moves out with ATT and they're limiting the ability of apps to gather information about what people are doing on their iPhones, you get complaints, right? When Google announces that it's shutting down access to third-party cookies, you get complaints, right? You guys are keeping it all for yourselves. To be clear, these may be good things. I'm not judging it negatively, but there is a tension, right? There is a trade-off inherent. And I think, when we talk about privacy, it's just not something that we necessarily see as an offshoot of natural market competition, right? Privacy harms, to the contrary, mostly are kind of externalities of natural competition, which is precisely the argument for regulation. And what I worry about with this focus is first that enforcers will just be spotting something that doesn't align with their preferences and calling that a harm. I think that's problematic. But more than that, I just worry that we won't be successful. Because only if you think that good privacy protection is the natural kind of market clearing outcome, do you think that competition law solves it? Right? Otherwise, and I think this is the right place to be, it's more regulation. So there's someone wearing a DuckDuckGo shirt. And I do want to give one example that I talk about. If I saw Google try to buy DuckDuckGo, right, which is really distinguishing itself on privacy, and privacy is the aspect of competition, there I'm going to be suspicious. Sorry, I don't know if you're planning to sell Google. But, and the reason is...
Share prices of DuckDuckGo have just gone down.
I just said I would be suspicious.
You're moving markets.
I rarely do that, if ever. We can look at privacy in the context of competition enforcement, but privacy isn't always a byproduct of competition. That is, in fact, the point of privacy regulation. And I just think it's important for us to keep that in mind.
Yeah. Let me switch gears now a little bit, kind of getting out of privacy and talking more general FTC esoterica that only people like us are concerned with. So in the wake of AMG, everyone's familiar with the AMG decision. I'm sure everyone in this room is that got rid of 13B authority, or at least the ability to go get equitable monetary relief in federal courts under 13B. Of course, that's gone, and the FTC, of course, still has some arrows in its quiver that it's been using. I noticed in resident home case, you and Commissioner Wilson dissented on that. That was settled as a Section 19, I believe, and of course, then we saw the penalty offense letters with the synopses, sent out with great fanfare about a month ago. What I'd like to, it's kind of a two-part question, is one, what do you see the limits of the current FTC's toolkit, sort of the Section 19, the penalty offense letters or whatever, to get money to engage in, to get efficient deterrence, for to talk like an economist. And second, what do you think the fix to AMG should look like? I know that there are a few things floating up on Capitol Hill, and I know, so what do you think?
So I'll do 19, then penalty offense.
I know there's a lot on the
letters,
table. So.
And then back to the fix, because I think actually the fix is related. The fix ought to be related to the concept behind both, right? Both Section 19 and the provision that allows us to send penalty offense letters. So Section 19 is narrower in the scope of liability than Section 13, right? It has a limitations period, and it basically puts you into a fraud or like fraud category in terms of the conduct that you can reach. It also has certain prescriptions for what kind of monetary relief you can get. You can clearly get monetary relief, but it's not anything you want. And it's certainly not a penalty. And you're already beginning to see district courts rendering decisions about what the scope of Section 19 is and what it isn't. And one thing we're going to be talking about a lot for those who really geek out on FTC law is like Figgy. And what is the future of Figgy? That's a case from the Ninth Circuit from way back when. The penalty offense letters, just for those who don't track this stuff, so there's this really funny provision of the statute. And what it basically says is, we can let you know about the result of a litigated case, and if you are aware of the rule from that case and you violate the law, not only can we go after you with the normal tools that we have, we can actually, it's a little convoluted, but we can get a penalty against you, right? We can penalize that conduct. The underlying intuition of the thing is very clear, which is when you know the thing you're doing is wrong, and you do it anyway, you can be penalized. And that goes, James, to your point about efficient deterrence. Likewise, with Section 19, because the liability predicate includes sort of fraud or something like fraud, right, dishonesty, you're aware that what you're doing is wrong when you do it. It's reasonable to hold you to that standard and to penalize you if you violate it. I think we need help on 13B from Congress. But what I don't want to see, and where I fear some want to go, is sort of a proxy for, or actually the power to get penalties in the first instance without the defendant being aware that what they did was wrong. The point of the FTC ab initio, right, 1914, 1915, was to go out and spot business practices that maybe courts weren't tracking, maybe Congress wasn't tracking, but that were bad. And we would let people know what they were. And once a company was under order, or once people were aware of the liability that a court had assigned, and they still violated it, you could penalize them. But saying to people, we're going to penalize you, but you don't know what the law is yet, it's fundamentally unfair, and sort of economically speaking, it's really inefficient, because you're not going to know where you can move. And that's going to deter innovation, which is good for America. So what I want Congress to keep in mind when they do 13B is that fundamental principle that animates all of these features of the statute, this basic idea that it doesn't make sense to deter you from doing that which you don't know. It makes a lot of sense to say, don't drive 65 or over, and if not, I give you a ticket. But if the sign says, don't drive at an unreasonable rate, it makes no sense. And that is the most important thing that I want Congress to keep in mind as they look at 13B.
Okay, delving even deeper into esoterica, I think, but maybe not. And this has to do, I think it's actually kind of important, some dissents that, again, you and Commissioner Wilson issued earlier this summer in conjunction with two things. One was, and again, it's the sort of esoterica that may fly off the radar screen of other people, but I do think it's important that there was the revisions to the Section 18 rulemaking, and there was the Omnibus Resolutions, which, again, sort of snorefest to the uninitiated, but I think it's really important. And would you want to elaborate on why you in particular were dissented on this, and what these issues raised?
Sure. So two different issues, but both getting to the fundamental question on what are the appropriate checks on actions that the Commission takes. So on the Omnibus Resolutions, what we essentially did for a bunch of fun areas is we took the authority of the Commission to issue compulsory process, mostly in antitrust cases, and we delegated it to one commissioner, which as a practical matter means the chair or whatever the chair wants. That's something we've done on the consumer protection side, but I, for one, think there's a real benefit in giving commissioners the opportunity to sort of test a little bit before we go and spend a lot of federal resources and a lot of time and money on the part of potential defendants on an investigation. I give a lot of credence to what staff wants. In almost every case I can think of, I am supportive of their investigative efforts. But as we test the bounds of the law, and there's all sorts of inputs that I'm less comfortable with, I think it is important that the work have a couple of eyes to check it. I think that leads to better work. So that's the Omnibus Resolutions. On the, the Section 18.
Yeah,
look, so Magmos is something that was imposed on the agency following National Petroleum Refiners, which was this case in the 1970s that said we had the authority to make rules under Section 6G. And Congress said, hold on. If you're going to make these UDAP, unfair and deceptive acts and practices rules, you've got to go through a longer process because you've got a lot of room to move under your statute. That's by design. But when you're turning enforcement into regulation, which is another thing entirely, you need to come and be level with the public a lot more. I'm worried that the changes we made took public input out, reduced the amount of time and the ability of the public to stand up and say, I don't like what you're doing. You're doing it the wrong way. It is ironic where we hear a lot of talk about opening the agency up and democratizing rulemaking, that one of the first things we did is, on a partisan basis, adopt a set of rules to limit public input.
Yeah, no, and that's I did want to ask you about that. I'm now going to move into some audience questions. I've been given some, and this is actually a great segue. It's a question about zombie voting. I mean, so other than sounding terrifying, walking around the building worrying about zombie votes, maybe you could talk a little bit more seriously about what exactly the zombie vote refers to, and what sort of concerns this raises.
So this came up in the context of the Commission's adoption of a policy on prior approval in antitrust settlements. So not just settlements, but mostly settlements. Essentially, the Commission withdrew a policy from 1995 governing when it, in a consent, resolving an antitrust case before litigation, was going to require that both the parties to the merger and the divestiture buyer, like the person who raises their hand to go help with that, would have to get the affirmative approval of federal regulators before doing future mergers. So I want to leave aside the policy, and you can all read my dissent. I thought it was very bad policy, so the dissent is rather strident. But one of the things it was based on was this zombie vote from Commissioner Chopra, who was no longer a commissioner at the FTC. And the vote was cast, I'm trying to think of what I can say publicly, weeks before the final decision. So there's this really interesting case from the Ninth Circuit involving Judge Reinhardt, who voted on a case and drafted a decision and then passed away before it was issued. And so the Supreme Court looked at that in the context of a statute on the judiciary making decisions, and it said, no, you can't do that. But the logic of the thing is really important to me. Because what the Supreme Court said is, this is a case called Jovino, until it's done, while the statements are being drafted, there's discussion, right? Judges make decisions on panels in appellate courts as a collective, not as individuals. And that's the same thing. That's the design of the commission. So leaving aside the legality of the vote in the first place, voting and then not permitting that discussion to go on, I don't think is what Congress wanted when they adopted a commission. I think it's bad government.
Yeah. So maybe you can't reveal this, or maybe what's the over/under on how many zombie votes are left?
I mean, I can't reveal sort of what's pre-decisional. I've seen some press reports about this with a lot of quotes from people at the CFPB. I don't know where those press reports are coming from, but as far as what more we'll see, I couldn't say.
Okay. I figured I couldn't pin you down, but I thought I had to try. So here's another question from the audience. So why hasn't we talked about rulemaking and Magmos and Section 18? So why do you think the agency hasn't significantly utilized Magmos in the past? Are you concerned about the FTC utilizing it ever? Or is it just a way about how it is it just the way you think it's currently being approached?
So we have used Magmos, and there was an effort that I hope we continue involving negative options. There was a rulemaking effort that began under Chair Simons. We've now issued a policy statement which I think is really important because we're addressing what I think is a really important consumer need, and that is the ease of cancellation for a negative option. I can't imagine I'm the only one in this room or watching who's found it a lot harder to cancel something they signed up for, like a lot harder, than it was to sign up in the first place. And that can be a real problem for consumers. So we do use Magmos, but it's a longer process, right? And it involves a lot of input. It also involves some features that I don't know that we've ever seen utilized. Magmos effectively allows people who have an interest, let's say consumer advocates or industry, to come in and ask questions, effectively litigate issues that the agency is considering. And I think as our regulatory ambition gets greater as an agency, I think you're going to see people using these tools. I don't know that you will, but I think you may. And that, from the sort of geeking out on administrative law perspective, I think that's going to be really interesting to watch.
So, okay, so another question from the audience. Would your comments on privacy rulemaking apply more or less to penalty offense authority? And so the way I take this question would be, could you envision, number one, what do you think about penalty offense authority? I know we talked about it a little bit, whether that's, and that maybe fits into your view of, at least you have noticed that the FTC has decided some business practices violates Section 5. And do you think this could be a vehicle to go after privacy or data security issues?
So let me say two things. The tool is there. It exists in the statute. I don't think we should pretend it doesn't. I supported the issuance of the letters. The trick with penalty offense authority, synopses, whatever you want to call them, are the facts of the case in front of you with the defendant, right, clear from the underlying actions that were finally decided, that the agency is relying on. And that's why I think that's the big reason you haven't seen the authority used in the past. It has to be pretty clear to the defendant that what they were doing violates the law. And that's going to be, the application of these, that's going to be the sort of more difficult question. But look, I think we have the authority. I think we can use it. I know the Chamber of Commerce is concerned, but I supported issuing those letters. I think they stand for important rules.
Okay, yeah, and I imagine also in the privacy and data security context, as far as, you need a fully litigated administrative decision, and right now, at least in the privacy context, in the data security, we have LabMD, which, and then the privacy, there are no admin decisions that have been litigated. They're all settlements. What?
Sorry.
Oh. What is your what is your advice for the digital advertising industry for how to engage most productively with the FTC? I wonder where that came from.
I think I want to go back to something I said before about what I'd like to see in legislation and the sort of important principles I think we need to vindicate. The thing I hear most often, when I'm listening to people complain or members of Congress speak or what have you, is again this sense of a lack of understanding. I don't think people have a good sense of what is happening to their data. And I think that to whatever other kinds of harms exist, that really exacerbates them. There's no context I can think of in my life where uncertainty doesn't make worry greater, right? Because you don't know what's happening. And so I think that, if there's anything I would like to see, it's innovation in the context of letting people know how data are being used. I would also like to see less hypocrisy. I love when you get editorial page people complaining about what company does by a company that's doing the same thing or worse. But leaving that aside, I do think additional clarity for consumers and really thinking about what is the best way to convey what's going on. Right? How do you lead to consumer understanding? Some of this stuff is going to be complex, but that's not the end of the conversation. There are lots of areas where you have complexity in the operation of markets where we think consumer understanding is important. and we find ways to sort of deal with it. I think government can have a role to play, but I certainly think the private sector can as well.
Okay. Well, I think we're kind of right up at time. If I'm. Then we
More questions.
We have so I'd open it up if there are any more questions from any more questions from the audience. Okay. So
Just please repeat.
okay, I'll repeat it. I guess we're playing a game of telephone, Jessica.
So it's Jessica Rich. So when we were talking about the connection between competition and consumer protection, obviously you cannot mix the remedies and mix the laws. But you are a commissioner in an agency that has both missions, and presumably you shouldn't just be bringing competition cases that are contrary to the privacy mission, or or bringing privacy cases that are contrary to the competition mission. Do you and the rest of the commissioners have an obligation to try to reconcile the different goals of the two missions? They are placed in the same agency.
Sure, although they're not solely placed, right?
Yeah.
The antitrust laws operate also through private lawsuits. The Department of Justice has authority to bring them. Let me say two things. I think it's really important to keep both things in mind, right? And so if you were looking at a kind of business conduct that, let's say, had a negative impact on competition, but it came from an earnest effort to improve consumer privacy, just as we, I think, are commanded under the law to take serious credence in the context of considering the business justification for the action, elsewhere, I think we would have to do it for privacy. By the same token, if we're looking at regulating in the context of consumer protection, I always want to keep competition in mind. I think there is a bill of goods being sold to the American public about the degree to which competition and regulation always align. I think this idea permeates the president's executive order, where they basically say any regulation we like is good for competition. That's wrong. It's just categorically wrong. There are some regulations that can help stoke competition, but the notion that they always do, I think, is risible. So I think we need to keep it in mind, but I also think it's important that we be mindful of the fact that the doctrines are not the same. So you see right now, for instance, an attempt to take all sorts of social values and say antitrust can solve this, antitrust can solve that. I think not only is that not what antitrust is designed to do, and so the remedies, among other things, won't succeed. I think that if you take seriously these arguments, what you may end up with is less competition. So let me give an example of this. We had this case, Arch Coal, Peabody Arch Coal. It was a joint venture, but essentially a merger of two mines in the southern Powder River Basin. And we alleged that combining the two would lessen competition, and this would raise prices for coal plants. And one of the arguments made in court, and this was litigated, was that, oh, no, we won't have power to raise prices because there's a long-term trend in the US. We're going to close down coal plants, and we're going to set up cleaner natural gas burning plants. And the response was, that might be a long-term trend, but at the end of the day, you're still going to have plants burning coal for a long time. And so this competition to sell to those plants matters. Why am I bringing this up? If you take seriously environmental concerns, which I think a lot of people do, and if you take seriously some of the racial equity concerns that you'll hear from, let's say, Commissioner Slaughter, it's not clear to me that making sure that coal prices are low and leaving coal plants running for longer are good for those concerns, right? It's not clear to me that that's true, but there was going to be a lessening of competition. And when you start pouring into the vessel of antitrust all of these other doctrines, what it actually counsels is less enforcement, and I'm not sure that's where we ought to be.
Okay. So do we have time for one more?
Yes.
Okay, so can you comment, Noah, on the role of self-regulation? What do you think about self-regulation in this area?
I mean, I think it's good,
Okay.
right? I mean, I suppose it depends what the self-regulation is. Look, I said this before when it came to consumer understanding of the business practices of companies with respect to how data about people are treated. I think there is a role for government. I don't think that self-regulation is enough, depending on the context, but I think that's an important additive to the work that we do. I'm glad Mary Engel is involved. I think you need to have both. I think that's helpful. We're not always going to be there. Congress isn't always going to be able to legislate immediately, but responsible members of industry can spot practices that aren't good and get together. Now, I hope they don't get together in an anti-competitive way, but I do think in general that's a good thing.
Yeah, and of course the FTC, I know in the privacy area, the FTC, when you has made sure to that if you have a seal, that it's actually a legit seal, because that's kind of one of that's one of the potential problems of self-regulation. But you're right, as long as so there is kind of a role for both. So the last question I have here, and I think then is are there places where sector-specific laws or regulation you think are appropriate?
Sure. I mean, I think there are lots of places, and in the context of privacy, I often see the critique that in Europe they have a privacy law, and we don't. And that's not really right? What we have are a series of laws and regulations that are keyed to areas, I think, of heightened interest, It's not insane to think that health information and financial information and information from kids are treated with greater care. You may want to have more law. I think that's a fair debate. But I think identifying particular areas where harm may be more likely, or identifying particular areas where we've seen enforcement and maybe we want to add a rule. I think that all makes a lot of sense.
All right. Well, I do think now we're at our time limit, and I want to thank you, Noah, for the time and for your great answers. So thanks, and we'll do this again in 6 months, I think.
I look forward to it. Thanks for having me.
Those of you in the room and those of you joining us on the internet. There's a lot going on in privacy right now, so we feel like this event is really well timed. And I'd also note that it's the day of the NAI holiday party. So we thought we would do something extra fun, not just celebrate it in the usual way, but we would get together with a bunch of friends and a bunch of privacy nerds, and we would talk about privacy, because that's what we do. That's what we always do here at the NAI. We really don't have a day that goes by without doing that. But so today is an extra special day. It's a holiday party. We've got this great event. We had that conversation, which I think was just super informative, from Commissioner Phillips and James Cooper, two of the smartest and most articulate people that I'm ever around. So I'm very pleased to have been able to kick off with that discussion. But we'd also like to broaden the conversation a little bit, because there's a lot going on at the FTC, and there should be, but there's a lot going on more broadly. There's a lot going on in Congress. There are a number of proposals on consumer privacy, national privacy frameworks. There are almost every state is engaging in drafting and considering privacy legislation. And as we all know, it's a major issue around the globe. It's not just in the US. So I'd like to have a conversation that's a little bit more broad than the FTC. Obviously, I want to talk a lot about the FTC, and we'll talk about the Hill and talk a little bit more broadly. I've got 3 guests here today that I don't think need a lot of introduction, but I'd like to say a couple words about all of them. They're all great friends, people that I just admire and respect a lot. And have you all been to an in-person panel post-pandemic, or is this your first?
No, this is my first.
This is cool. This is super fun. And I know we've done a bunch of virtual stuff together, but so it's great to get you guys and Jessica here today. So I'll start with Jessica Rich, who I think I'm certain you all know has spent many years and built her reputation at the Federal Trade Commission. Someone who's really devoted her life to consumer protection and privacy as a large part of that. I think probably as the bulk of her career. I'm not going to say how long she was at the FTC, but we all know it was long enough, and it was extremely valuable. It was during the time when the privacy program was being built. It was before most of the rules and statutes that many of us are talking about and thinking about and even talking about tweaking today. And Jessica, after being at the FTC, spent some time as a privacy advocate for Consumer Reports, and a little less well-known, Jessica also did a little bit of consulting and did some work for the Privacy for America Coalition, where she worked very closely with me and a number of my colleagues. And we'll talk more about that, because that, her contributions there were maybe not as valuable, but I think extremely valuable. And I certainly enjoyed it and learned a lot. In the middle here, we have Travis Hall. This is not Jared. We had initially hoped to have Jared Bomberg with us today, and he couldn't make it, unfortunately. He sends his apologies, and we're confident that we'll be able to connect with him in an event in the future. But I'm filing this one under shame on the event planner for expecting to get a senior Hill committee staffer on the day of a hearing. So no worries to Jared. I hope you're watching online. They've got a big hearing this afternoon. One of the big social media companies has their regular hearing before the committee this afternoon. But in his place, we have someone who I think is equally smart, equally charming, and one of the most engaging minds on privacy that I know, that I've worked with, Travis Hall, who's been at the NTIA for about 6.5 years now, and has spanned through 3 administrations. And that's impressive. As a career guy, he's been able to just contribute in a whole bunch of conversations, and I think kind of quietly, but not quietly to many of us who have been engaged, really helped to drive the policies that the administrations are talking about around privacy, and more broadly for that matter. But Travis is fantastic and always has a great attitude. I've never seen Travis at a time where he was down, or some of us can get a little grumpy. Travis doesn't ever seem to do that, so it's great to have you, Travis. And finally, Christian Fjeld, who's also a friend and someone I've known for quite a while, and someone who most of you know, I'm sure, spent a long time on the Hill. He started out on the House, like many folks do. 20 years? Is that okay to say? You don't mind? Okay. 20 years. Started out on the House side, worked for distinguished members like Representative Rush, and worked at the ENC, and then spent a lot of time in the Senate Commerce Committee, where Christian worked for 3 different chairs. I believe it was Rockefeller, and then Nelson, and then Cantwell, and then you said you had enough, and came, and now landed at the perch there at now as a vice president for ML Strategies. So Christian has probably, in that time, just doing some basic math, I think Christian has probably spent as much time writing and negotiating legislation on privacy and data security as anyone around here, anyway. And that's pretty impressive. And Christian's also been someone who's worked in a real bipartisan manner. So it's always great to talk to you. Always great to have you. Thanks to the 3 of you for joining us today. I'm going on way too long. I thought what I'd like to do, we've got a lot to cover here. I thought maybe for starters, since we had that great FTC conversation, it's the holiday season, so I can make an analogy. Maybe we could just like those little wind-up cars. We could just wind up Jessica and have her start out by responding a little bit about the FTC. You've got a lot of knowledge, you've got a lot of perspectives, and you've been thinking and talking a lot about what's going on at the FTC. And I think it's fair to say that the FTC is at a critical time. Many of us, if not all of us, believe they need more resources. They need to do more, and we're all supporting that. So it's a great time, and maybe use Commissioner Phillips' remarks if you'd like to, and just talk about and react a little bit about where you think the commission is at, what's really important, and give us your views on that. That would be a great way to start.
Great. Well, he listening to him was great, and I found myself, I'm a lifelong Democrat, and I served in the Obama administration, but I found myself agreeing with a lot of what he said. But thank goodness there were some things I didn't agree with him on. It's kind of a joke. No laughter there. But let me back up a little, and he mentioned a lot of things, but for those that aren't following every little thing that's going on at the FTC, maybe I'll just use this as an opportunity to give my high-level summary of where I see the FTC right now. So, as many of you know, the FTC is moving forward to issue on an aggressive agenda. It's doing this with an eye towards compensating for real gaps in its authority, which have gotten worse, actually. Limited civil penalty authority, limited rulemaking authority, no federal privacy law, although there are laws, as the commissioner pointed out, and now limits on even the FTC's ability to get consumer redress, to give money back to consumers. And Khan is definitely also trying to fundamentally reshape the way the FTC is doing business. Let me just give some details about what's going on, which I'm following very closely. So the FTC was, when it was 3-2, when Commissioner Chopra was there, it was engaging in a lot of 3-2 votes. So it was abandoning to a large extent, at least temporarily, its bipartisan traditions, at least for now. Now it's 2-2 because Chopra has left, and Commissioner Bedoya is held up because of his bad tweets and delayed, although I think people believe he'll ultimately be confirmed. I think if and when he's confirmed, it's going to change the dynamic a lot, because I know him and a lot of people know him. He's very collegial, and I think he'll care about the dynamic. I'm not sure it's going to change the votes that much, because he's very aligned with where, at least as far as we know, with where the chair and the other Democratic commissioner are. But it will change the dynamic, which is good for the agency. One thing that's gotten a lot of attention, and it's very true, is there's a real disconnect between the new chair, Khan, and staff. There's been a lot of turnover because staff has been, because there's just not a lot of communication there, and there's a lot of public denigration of what staff has done in the past and prior commissions, which people who've spent their career trying to protect consumers don't really like that much. And by the way, people who spent their 26 years, I'll say it, at the commission dedicated to protecting the consumers, they don't like it that much either. There's no big reorganization yet, but there's been a lot of hiring within the chair's office of privacy and data protection people. And so it's felt that a lot of decisions are probably being made from there. And as you mentioned, the Build Back Better reconciliation bill contains two very significant provisions that would affect the commission enormously if they're passed. First, the $500 million would be a whole lot of money for privacy. And second, penalties for all of Section 5 would be a very, very dramatic change. Although one thing people fail to realize is that there's still a knowledge requirement to get penalties. So it's not without notice that it's not without notice of that you're violating the law. Khan has issued two big vision memos that show she really wants to change how the FTC does business. The commissioner talked about the integrated approach between competition and consumer protection, focus on gatekeepers and root causes, not whack-a-mole enforcement, as she called it. We're not sure what that means. More substantive remedies rather than process remedies like notice and choice. In the privacy area, focus on platforms, what she's calling surveillance advertising. That's you guys, even though you don't call it surveillance. And sensitive data, updating existing rules like COPPA, developing potentially new rules on privacy. We can come back. I think that'll be something you'll want to talk about rather than me going on and on about the new rules. But it's a really interesting idea, Magmos rules on privacy. The warning letters we talked about, there is at least one litigated case in privacy, and in an article Chopra and current Bureau Director wrote last year, they talked about using warning letters in privacy based on that one litigated case. They mentioned two cases, but the second case probably doesn't qualify for use of the warning letter strategy. But we can talk about that more if you want to. And then, now that I'm a firm, I know I can attest to the fact that we're getting high demands for both money and remedies in consent negotiations, pretty out of proportion to what the law requires and what the precedent has been. There's also more teaming with states and other agencies in order to supplement the authority that the FTC doesn't have to get monetary penalties. And then the final thing I say, because I know I'm going on and on and on, is that I'm not sure where this commission or where this chair is on self-regulation. We haven't seen a lot of supportive statements. We did see the yanking of one self-regulatory program under COPPA. But I do think that NAI is in a solid position because unlike a lot of self-regulation, it's not just words on a page, but it's a whole robust program that you've been working on to add to over the years. So I think that if any group, and Mary's in the audience too with BBB, I think, you are groups that are in a good position on self-regulation, but we'll have to see where the commission is in general on self-regulation. So that's my big spiel, and I'm happy to answer specific questions and let the other people speak.
Great. That was perfect. And I should jump in quickly and just say I was remiss in noting, actually, that you're now with Kelley Drye. I knew that and just got so excited about the other stuff. So congrats to you on that, being of counsel there. And congrats to them on a great hire. So
thank you.
That's super cool. I thought, since Jared's not here, maybe we could pivot to you, Christian, and talk a little bit. And I know you don't come from the commission, you're a Hill guy, but you worked with the commission very closely and worked on a lot of legislation about the commission. It used to be Jared, exactly. So you used to sit in his seat. So pretend you're Jared. He's out of luck for not being here. If you would talk a little bit about your perspective in terms of what's going on the Hill, those proposals, and where they're headed.
So thank you. And David, you forgot to mention that we're also fellow Wizards fans.
And we're in Washington, D.C. We can put it
big basketball fans. So I'm always struck, and this is sort of a spiel I always say when I do these sort of panels, about how little in so many ways the debate and the issues have changed over 20 years that I've been working on privacy issues. When I first started on the Hill in 1999, the issues was notice, choice, and security. In 2021, the issues... it's notice, choice, and security, and access. There's some new concepts that are involved. I mean, I think there's a lot more duty of care sort of focus now than there was probably back in 1999 or even 2009. But the issues and the rhetoric remains remarkably static. They're not a lot different from one. So on the one hand, I think that after CCPA passed, there was sort of renewed hope, at least when I was still on the Hill, that there would finally be a willingness to come to the table, at least on the part of industry. Now, I say this as a former Democratic senior counsel of the Commerce Committee, so take everything I say from that lens, although I'll try to be as nonpartisan as possible, that there would be sort of more willingness on the part of industry to sort of accept certain elements of a privacy bill that heretofore they would not accept. FTC rulemaking under APA, for instance. And for instance, when we worked on Senator McCain's and Senator Kerry's bill, which was a very good bill, we worked very hard on that. It just ran into some roadblocks that didn't have quite enough, like my recollection, sort of support from some parts of the business community, and there were also some consumer groups that weren't necessarily supportive of it as well, which means you maybe hit the sweet spot because you had both the left and the right that were not terribly weren't satisfied with it, including my former boss, the chairman of the committee, Senator Rockefeller at the time. Anyway, having said that, my perception is that momentum has sort of petered out on the Hill a little bit. The sort of enthusiasm that came after the passage of CCPA, I think, has somewhat dissipated. And I'm only speculating on this, but from my conversations on the Hill, businesses are no longer really scrambling for the regulatory certainty that would come with the federal privacy bill after the passage of CCPA. And this is with other states considering privacy bills themselves. And I tend to wonder whether or not, because we saw this in the data security world too, and I worked forever on data security legislation with the carrot being preemption in exchange for fairly all sorts of sort of federal standards on security and notification. I tend to wonder whether or not large companies can sort of adopt to the states that bills and laws that are out there. Now, this is just speculation on my part, but it certainly happened in the data security world. The big guys basically were able to, they have an army of lawyers, they have a compliance staff. They basically adopted to the 48 different notification laws that are in the states and the handful of state laws. And I'm wondering if that's what's going on here too, because I have no inside knowledge, but I am just being told it doesn't seem to be as much urgency on the part of the business community to get data security passed. So I'd be certainly interested to hear from your perspective with the ad networks that are obviously going to be profoundly impacted by any sort of federal privacy bill, what your perspective would be, because what I'm hearing is that, as I said before, the sense of urgency is not quite there anymore.
Wait, what are these bills that you're talking about? I'm just kidding. Yeah, we spend, that was a great look. I hope the camera got that. We spend a fair amount of time on those, and you make an excellent point, as always. In fact, we don't really know what the impact is going to be. We don't really know what the industry's ability, ours and more broadly, what the industry's ability to comply with these disparate laws is going to be, but we don't think it's going to be good. So the urgency is still there on behalf of industry, and I can say that, and I think you all know that, and Travis knows it. We talk fairly regularly. But
When I was on the Hill, there was a saying, and we used to say from the Democratic side, the only thing worse than bad regulation is uncertain regulation.
Right.
Now, I don't know how that still is true or not, but that was certainly always our carrot when we were trying to negotiate with our Republican friends with industry. It was like, if you can accept some of the medicine that you don't really like, but it gives you regulatory certainty, will that be able to get us across the finish line?
No, you're absolutely right, and I think I did want to dig in a little bit. I want to get to Travis in a minute, but I wanted to dig in a little bit on something you said and about the the level of industry engagement and get your sense on this, because I think from the beginning of this conversation, and you touched on this a little bit, the biggest challenges here are those two big issues. What people refer to as the third rail issues, where you've got preemption and you've got private right of action. And those are still the elephants in the room. Do you think there's a clear path forward on those? Do you think there will be could be a federal bill without a private right of action that will provide strong preemption? What's your take on this? Because we've talked a little bit in the past.
So I hear two almost diametrically opposed paths on what you're talking about to getting a bill passed. On the one hand, you have one school of thought that says, and this is coming from the Hill, that preemption and enforcement, i.e. private right of action, is sort of 80% of the ballgame. Like, if you resolve that, everything else is negotiable and you'll be able to sort of get something across the finish line. There's another school of thought that says, no, it's actually quite the opposite. You got to get the other 80% right first, because once businesses understand what they have to do, what they have to comply with, then the enforcement and the preemption sort of fall into place. Now, I don't claim to have any sort of inside knowledge as to where you're going to go on this. Again, I would be interested to know where you all think on this particular subject. But I just throw that out there because the third rail, in terms of enforcement and preemption, yes, those are the two biggies. But I have heard from very respected and influential Hill staffers that they think it might be in reverse that they have to resolve in order to actually get the two big ones eventually resolved and across the finish line.
I think that's a fair point. I think we've all had those discussions, and we kind of we're going down both paths a little bit, on the Hill and in industry, but they're valuable discussions, and I do think there's some progress being made, and we can circle back to that. But on the notion of getting the rest right, and what are the other issues, because I do think those two issues get a little bit of outsized attention. They deserve a lot of attention, but it is important to talk about the other issues. Most of them are well defined, but there are some new issues. And I think over the last couple of years, we've been talking a lot more about civil rights and privacy. And that's not brand new, so it's not a brand new issue, but it's a new focus. It's a new energy, and I think a new urgency. And I think that's fair. I think that's right. And we've been engaging on it quite a bit. And I know we happen to have a guy here today who can say a lot about that and is working on a new initiative. So why don't you kick it off, Travis? Talk about what you all are doing, which I think is super exciting. And then you can take even more broadly if you want to talk more broadly about NTIA. And
yeah, absolutely. So maybe I'll do the reverse first. NTIA, who we are, who I am, where I fit into the general scheme of things, small cog that I am. So NTIA, National Telecommunications Information Administration, part of the Department of Commerce, and wears a bunch of different hats. Right now, the big thing, of course, is broadband, right? Like, we're getting lots and lots of money for broadband. Of course, we also manage federal spectrum. But the office that I'm in, we are the president's primary advisor on telecommunication information policy by statute. Unfortunately, that doesn't mean we have a bat phone. Whenever an issue comes up to the president, it means we go through, the secretary and through the White House. But we are heavily engaged on that kind of range of issues. And one of those that we've been really publicly engaged on through the years has been privacy. And that goes back to like the 90s when we were engaged on the Communication Act and the drafting of that, and of course some of the other bills as well, particularly the Obama administration's Consumer Privacy Bill of Rights, and then under the Trump administration, the 2018 request for comment. And I came in, like you said, at the tail end of the Obama administration, worked on some of the multi-stakeholder processes, worked on the request for comment, trying to get that administration into a solid place in terms of what it wanted to do in terms of policy. And I'm now working with this administration kind of in a similar way. And putting it out there, right? These issues are hard, right? They are complicated, and so the administration has had quite a bit on its plate. And so I think that, attention has been paid within the administration to these issues. We've had lots and lots of conversations. A lot of the focus, of course, has been on trying to get to a deal on the Privacy Shield framework with the European Commission, and we have been very supportive of our commerce colleagues in the National Trade Administration in terms of helping to get them to there. But then also in terms of just a lot of the broader scale things, privacy gets touched upon in lots and lots of different areas and lots of different ways. And but in terms of the conversation that we're having today about that kind of like nebulous Section 5 area that everybody kind of is looking at and wanting to update, with the initiative that we're putting out is to kind of focus in on that particular slice, or that particular framing of the conversation, which is around civil rights and equity. So we're looking at the intersection of privacy, civil rights, and equity. We are a little bit about process. Next week, we are holding 3 listening sessions, December 14th, 15th, and 16th. They will be open to the public, and we're really excited about them. More information is on our website, and more information coming soon. Followed by a request for comment, and then finally a report. But, process aside, why we're looking at this particular area is that, 2 reasons. One, I think that to what Commissioner Phillips was talking about before, about a focus on actual harm, a focus on where the rubber hits the road. I think that a lot of the conversations around privacy, when they are a little bit more sophisticated, do focus a bit more on risk. And and the ways in which data is collected and used contextually, and what the particular risks of those contexts are. And I think that an area that academia has been looking at for 20 years, like you said, this isn't a new conversation, but I think that only has recently become a focal point of kind of the public policy conversation, is what those disproportionate risks are for different communities. Right? And so I think that by structuring this, by looking at what some of the higher risk areas are, what some of, we're talking about sensitive data, but what does that mean for, like, in terms of information that is collected about someone or a data breach, right? Like, most of us can handle a credit card being gone for a week, but some people can't, right? But then, and I would want to point out that this is part of kind of a, absolutely part of the broader administration push on questions around social equity and moving forward on these questions. OSTP had a series of events last week focused on artificial intelligence and its relationship to equity, and has had 2 listening sessions specifically on biometric technologies. And we're not focused on, I think that artificial intelligence and machine learning will be part of that conversation, but it's not the only one, because there are areas in which the collection of data has disproportionate effects, right? Where people are required to provide particular information in order to participate in certain, socially necessary activities, and not everyone has that, or it is an excessive burden in order to get that, where you have to go to the library in order to provide information, or to, how to do 2-factor authentication when you don't have a cell phone, right? There's lots of these areas that I think get touched upon that, again, not a new conversation, but I think that it's helpful to refocus. And I'm hoping will help to also reinvigorate the privacy conversation in terms of saying, okay, refocusing in on, well, what are these harms, and where is the harm most acute, and how can we work a little bit backwards in terms of alleviating that. And it's really interesting, like the notice choice security, right, piece, and access. I think that is the focal point of the conversation, and I think a lot of it is like, how do you get beyond just notice and choice, right? Whether that kind of next step, where of course choice is always an important part of it, right? You always want to be able to gain consent, to able to have people be able to choose what they are doing with what is being done with data about themselves. And of course, transparency and notice is really important too. But in terms of that being everything, I think that we have seen that it is absolutely insufficient. And so the hard question is okay, then what else, right? So notice and choice, we've kind of got that. What is the additional? How do we get beyond that conversation? How do we actually put in place other structures? And I'm a little bit on the side of the 2080 in terms of the enforcement versus the details, where I do think that the details are actually quite hard. Not saying anything about Hill politics, just simply in terms of what my mind is like the difficulty of the conversation. I actually think that the details of what the standard is actually, somewhat unsettled. And the bills are, there is some, you're starting to see convergence, which is great, and I think shows the maturity of the conversation at this point in time. But it is still like the harder part. And ultimately, at the end of the day, I do think that there's a little bit of a question between, do we want Congress to decide? Do we want to kick it to a regulatory agency? Or are we kicking it to the courts? And to a certain extent, all three are going to have a role in it. It's a question of how much. And I think ultimately that's a decision of Congress in terms of how much detail they put in and in terms of what the next two stages are going to be. But this is me just kind of like a little bit talking off the cuff.
Right. No, and it's always valuable, Travis. I appreciate it. You actually touched on most of the key issues that I wanted to kind of jump in a little bit deeper on, so that's perfect. And maybe we should start with notice and choice, because I feel like we're constantly all finding ourselves around tables, I feel like, and have been for years in Congress. They've been holding hearings, and people will line up and one after one say, well, it just doesn't work, notice and choice doesn't work. And then, but what is the number one tool, for all the proposals, whether it's the states or federally or internationally, it's notice and choice. And I think the rhetoric doesn't match the reality, and that's unfortunate. As many of you know, and certainly you all know, you're all very familiar with the Privacy for America framework. That's exactly what we set out to do years ago when we put that thing together, was to come up with a model that doesn't focus so much and doesn't put so much responsibility on the consumer. It recognizes the fact that consumers can't practically make informed decisions across so many, that it's just not practical. And that was our product and our outcome. And we're still very proud of it, and we're proud of the work that Jessica did for it. So that's a conversation I'd love to hear a little bit more on. And there's a related issue that I'll throw out there that I also spend a lot of time thinking about and talking with folks about, is the duties framework. And that ties into some of the stuff you're talking about, Travis, which is, the duties frameworks we're all familiar with. I think Senator Schatz was probably the one who led on the Hill popularizing this concept. He's kind of the one that I think of as a leader. And it's a bipartisan concept that is in a number of proposals at federal and state level. And it's a great idea. I think on many levels, it's great, sounds great, but in practice, it can be kind of a nebulous kind of set of rules for businesses that just doesn't work that practically. But in many ways, that's consistent with what we tried to do, Jessica, in Privacy for America with an unreasonable standard. And to be clear, we were a bit ahead of the curve, I feel like, here. We and others in industry rolled out years ago with the Federal Trade Commission needs more money. The Federal Trade Commission needs more staff. They need a new bureau. And they need rulemaking in this area. So I feel like industry is aligned, and there is this big debate still now, as you mentioned. Well, should they pass this bill and give a bunch of new money without new rules, including civil penalties? I think, so I'm going to throw a bunch of stuff out and then just shut up, and you guys, have at it. Should they do that? Is it prudent? Is it time to throw up our hands and just give them a bunch and give them, $500 million and civil penalty authority? And then I'll swing back to Christian to get his take on whether or not he thinks that'll fly procedurally. Do you want to start by kind of responding to some of those things, notice and choice?
8 things you just talked
Yeah.
about?
Anyway, you pick one. You pick one. You're the expert.
Well, okay. So Privacy for America, I think it was a very bold and ambitious effort to flip the model and try to prohibit concrete practices so that even if consumers don't take any action, opt in, opt out, whatever it is, the worst harms would be off the table. Stalking, discrimination. The trick is in the drafting and getting everyone to agree to it. The use of data to deny people important benefits, that kind of thing. I don't think it got that much traction. even though I think people are intrigued with they talk endlessly about, and you would know better than I because I'm no longer working on Privacy for America, but nor do I think that the shots approach has really, dominated the thinking, the duties model, which is similar. I do think, when I first looked at the shots bill, I thought it was completely unenforceable because I always think in those terms because I was an enforcer for so long because it's so vague. And all the complaints people have had about Section 5 would be even more true of the shots bill. So maybe you could marry, sort of the Privacy for America model with shots, add some rulemaking as long as there's enough structure in there to prevent people from freaking out about FTC rulemaking. Maybe you could have a model that's less focused on notice and choice. But as I said, I'm not sure that's really taken hold. I think most of the models are still very focused on notice and choice. In terms of this, I missed all the stuff in the middle, which we can come back to. But in terms of the stuff you said at the end about the Build Back Better provisions, the FTC absolutely needs more money. And so regardless of whether it's a new bureau or whether there's more authority, even Commissioner, the commissioner said, Commissioner Phillips said, the FTC needs more money. So I think the $500 million, whether or not you agree that's the right amount, is warranted because the FTC needs to be on a par with other agencies. The FTC needs to be able to oversee privacy nationwide. 50 people is just not enough, even though I think they have done a good job. The civil penalty is a trickier issue, and there may be bird rules, and we have an expert here who can tell us about that. But I do want to remind you that the knowledge requirement, I went and I matched the amendment with the actual language of the statute. I stuck it in, and yes, there's still a knowledge requirement. A company that's liable for civil penalties under this new amendment would still have to be shown that they had knowledge they were violating the law, some level of knowledge. It's not just actual knowledge. So.
Yeah, why don't we shift back to you, and I'd love to get your take and put you on the spot here, whether or not you think that's going to fly, the civil penalty, and what you think about some of the other proposals, because we actually started out the year talking a lot about FTC with 13B in the wake of AMG. That was all the focus on the Hill, and then many of us were saying, hey, let's do something broad, and it was and now we're talking about not restoring restitution, but giving civil penalty. So what is your take on that as from a legislator perspective?
Okay, so again, keep in mind my background and where I come from. Civil penalty authority for Section 5 violations, even if there's some sort of scienter or knowledge requirement, certainly is a bit radical. When I was on the Hill, that was never really on the table. The thinking is that because the language of Section 5 is so capacious, you don't really have the certainty necessary in order to be punitive with some sort of penalty. Having said that, I also know that there's a bit of frustration that because there has been, at least in the past, opposition to providing the Commission with some sort of APA rulemaking authority, whether it's general APA rulemaking authority or even more narrow APA rulemaking authority. There has been a pivot to look at Section 5 civil penalty violation. The logic being is that obviously the Commission can seek civil penalties if there is a violation of a rule. Well, if on the one hand you clip the Commission's wings to do effective rulemaking, and with all due respect to Noah, who I do respect quite a bit, I don't think Magmos is a realistic tool on the part of the Commission to promulgate rules. At least my experience has been that they are incredibly burdensome and resource intensive, and that's why the Commission basically has not issued a rule under Magmos in, 30 years? And is it the credit practices rules?
There have been more recent.
Has there been?
The
Okay.
franchise and the.
Well, then I stand corrected, but I mean, at the time.
Contact lens, Mary? Oh, it was? Okay.
Yeah, and I'm not taking an opinion as to whether the Commission should have this sort of general civil penalty authority for Section 5 violations, but I'm trying to explain at least what may be some of the thinking on the part of Hill folks who crafted this provision. As for the $500 million figure, my understanding is that there is pretty much universal Republican opposition to this provision. I mean, I'm not saying necessarily anything too insiderish, but there is concern that the commission does not have sufficient accountability for this large sums of money. Not to mention there's all sorts of worthy, and Jessica would know this better than me, all sorts of scams and consumer cons out there that are just as bad as privacy violations, anything from, COVID scams to, opioid treatment scams that are worthy of the commission's attention. And so this complete focus on privacy violations, I can understand why some people would think that it's maybe a bit of an overreach. But having said that, the commission has, in my opinion, chronically been underfunded. When I was on the Hill, we always advocated for more resources for the commission. I have immense respect for the commission staff and the terrific work that they do under very, very relatively meager funds compared to other agencies, particularly considering the mission of the commission. And so I certainly think that I would join a lot of other people and think that it's long overdue that the commission is infused with new resources.
That's valuable. We're running really short on time here, and we do need to wrap it up. Unfortunately, we're not going to be able to take questions from the audience, but next time, or definitely follow-up conversations. I want to put to you really quickly, Christian, because it's on a lot of people's minds. Alvaro Bedoya, does he make it through? Yes, no. He's running some headwinds, but he's very, very, very well liked as well, and very smart guy.
And Alvaro is definitely a very smart guy. My guess is that it will probably happen. Although I'm not that good. I know I'm better at prognosticating who's going to win the 6th race at Laurel on a Friday afternoon than I am this type of stuff. But my guess is if I had to bet money, and I'm a gambling man, is that I'd put my money that he's going to be confirmed.
Okay, fantastic. I tend to agree, but you're smarter than me. I was going to press Jessica on whether or not she should have done Magmos during her time, but it sounds like the answer is no. You don't think it was the right tool.
Well, not to reveal non-public information, but I raised it once, and there was an intervention.
There we have it. There we have it. We are officially out of time, and I'll just plug one more time. The NTI work next week. Tune in. You'll be hearing more from Travis, and the NAI Summit, which is I think we're providing a link on April 28th. I think there's a link for the virtual folks, and anyone in the room can talk to us about it. We're excited about having a full day of conversation, not just an hour and a half. But thanks again, everyone, for joining us. Thanks to my excellent set of panelists. Great to have you all. Great conversation. Thanks so much.